Hi guys, it's Kathy. I hope you're doing well. We made it to Wednesday night. Can you believe it? Ooh, this week's gone fast. This week is sucking for a lot of us. Seriously sucking. But it's Wednesday. It's the second half of Wednesday, so we're in the last part of the week. We just got to breathe through it. Watch court videos. So I got a good case. I got a bench trial today. With the sentencing, I think. I'm pretty sure. But before we do that, we're going to go through a tiny eviction hearing. And then we'll jump into the thief. The thief? Actually, when you see people complaining about public defenders and how they don't work hard, it's just a bunch of bull. We see it all the time. And we're going to see a great public defender do a really good job today. But first, I think we should go through an eviction with a lesson.
So 2EV242, I'll show Mr. Bontrager appears. I have one of the defendants. Sir, what is your name?
Daniel Adams.
Daniel Adams. All right. Now, gentlemen, this is a hearing that was set after an eviction hearing. It's a money damage hearing.
Yes.
Mr. Adams, are you out of the property?
I don't live there. I never lived there.
Okay.
What it is, I helped my daughter.
Understood.
And I thought she was being loyal and stuff to me, but she deceived me as much as she deceived him.
Okay.
And I asked him, why didn't he evict her after 2 weeks or 2 months of not paying or even a month not paying? And she told him that she was coming in some money, stuff like that, which I don't know. She told me every week she was paying rent.
Okay.
I said, you promised me paying rent? Yes. I said, let me see her. Oh, I don't, like I said, let me see your, because she would pay with a money order. So let me see your money. Oh, I don't have it right now. She just lied to me. You know what I mean?
Okay.
And I shouldn't even be up in here.
Well, if you signed a contract.
But what it is happened.
Oh, hold on. So let me finish my sentence.
Okay.
If you signed a contract as a guarantor, as unpleasant as it is that your daughter and someone else didn't pay as they promised you, the landlord plaintiff probably only rented to them because of your guarantee. Mr. Bontrager, am I correct that
100%.
Mr. Adams?
Absolutely, you're correct, Judge. You know you're correct. I'm not guessing, I'm imagining he's wearing a football jersey under his robe.
Was a guarantor. Give me a second to set my eyes on that agreement.
See, Bob, Your Honor, if you don't mind me speaking, I feel like I'm being targeted because he should evict her after 2 months of not paying rent instead of waiting 3 years to evict her.
Let me stop you because it would really be helpful for me if I looked at this lease before we talked about
I
it.
appreciate it.
I don't see that a lease got filed.
Got one here if you want.
I'll ask my assistant to come get it. And I'll also ask Ray if you could please show Mr. Adams before bringing it up. And for the record, we'll show.
Actually, that could be a little orange. Just could be. Might not be red. Maybe the colors are tinted. And he is actually in prison garb. And he's out on work release right now.
Denise Haggerty and Joshua Perkins do not appear.
See, I never even got a copy of the lease. He said he was going to give me one.
Did you sign the lease? Did you sign it? I don't care if you had a copy or not. Did you sign it?
Where's it at?
Back sheet.
Man,
Flip everything over.
Yeah, that's my signature.
Okay. Then I'll take a look at that agreement. Thank you. Oh, okay. All right. Now I'll just look at the.
I never rent. I
understand, sir. So you signed on the last page as a non-residing co-signer. So when you co-sign for someone's obligation.
I understand that. I know where that comes from.
All right, then the story ends there.
But what I'm saying is, my point is, I know the law is I'm a co-signer, I signed for it, blah, blah, blah. But why did he wait 2 years to evict her if she was never paying him rent?
He has that right. My guess is there's a provision that says if he ever
That's a good point. That would piss me off too, but he can do it. It's legal.
waives non-performance for a certain month or period of time,
That's like targeting me.
that doesn't mean that he waives it forever.
I know, but that's like targeting me.
Sir, when you agree to co-sign for
I
someone,
understand where you come from. Okay, I understand that. But why did he wait for so long? When
he has that right, sir. He has that right.
Then what's my rights then?
So your right is to know when you co-sign on somebody else's debt, that worst case scenario, if they incur debt for an extended period of time, you're on the hook for it. You can go after your daughter and maybe son-in-law or someone else if you
She
want.
ain't here now. What makes you think I'm gonna get anything?
I'm just saying, you can if you want.
I understand you. I know where you're coming from. I'm not
So-
trying to be aggravating or disrespectful, but I'm just saying, no one's being targeted now because
You are
he
being
could.
aggravating.
I shouldn't even be in here.
No, you should be here because you signed as a co-signer.
Okay, I understand.
Let's stop. I'm tired of it. Stop.
Okay.
Mr. Bontrager, how much are you claiming from?
Well, it's not even close to the 10.
It's well over 10,000.
Yeah, the rent itself is 22. You can see the damages there were unbelievable. You see those pictures I sent up there. We still haven't got all the odor. There was dog crap all over.
I'll scan the photos in as well. Do you intend to have the lease and the photos introduced as evidence at a trial of this matter?
If it ever comes up to that.
Okay, then what I'll do is I'll have the lease go in as plaintiff's exhibit number 1 and the photos as plaintiff's group exhibit number 2. Now, Mr. Adams, when we have a dispute of liability, we don't typically have trials on this very day. If you agree that you have $10,000 of liability, please let me finish one of my sentences without interrupting me. That's like the 5th time.
Okay.
If you agree that you owe the judgment and enter into an agreed judgment and a payment plan, I can do that today. If you dispute that you have $10,000 in liability, I'll simply have the matter referred to my magistrate. He'll get it on your trial calendar. You'll get notice of that, and you'll have to come in and put forth any defenses that you might have.
Okay.
That's not today. So the question is, do you agree to a judgment or do you want a trial?
I'll trial it.
Okay. So, gentlemen, let me share when I refer this matter to my magistrate.
Okay, it's been 2 to 3 years that she hasn't paid any rent. So the most this guy can get is $10,000 in small claims. Okay. Now, what is this guy going to trial for? What does he think it's? Even if he drops the price down a little bit, it's at over $20,000. It's still going to get down to. I mean, it's still going to be $10,000. She hasn't paid rent in 2 to 3 years. So what does he hope to get at a trial? I don't understand why he trialed this.
The trial will not take place in this courtroom. It'll take place 2 courtrooms over on this floor in Magistrate Burton's courtroom, which is 4A. I am 4C. Magistrate Burton will get an order out giving you the date and time. It's likely going to be about a month out. That's going to put you the week of Memorial Day. It might be early June. I'm not sure. Bottom line is, please don't sit back and assume that he didn't set this trial. 90-something% of the times, he sets the trial the same week I make the referral. So if I make the referral on a Monday, by Friday, that trial date goes out. I can't tell you how many times I get a letter, like in this situation in July, Judge, I just learned of the trial date in early June and I didn't ever get notice of it. If we scheduled 2 trials for everybody who didn't get notice of it, we will be so inefficient. So I have to put the onus on you gentlemen. If you don't see anything a week from today, either go online and you can use that tan slip of paper to search my case, or you can call a clerk if you don't have computer capabilities. Either way, you're responsible for learning what your trial date. And then very importantly, Magistrate Burton's order will state that there's a deadline 10 days before the trial date. So if the trial is June 11th and June 1st is that deadline, you need to file all of your exhibit and witness names and addresses. So for example, Mr. Bontrager just tendered plaintiff's exhibit 1 for trial, which was the lease. Plaintiff's Exhibit 2, which was the photos. If there are others, pick up with number 3, 4, 5. Defendants should letter them, and the letters would be Defendants Exhibit A, B, C, D, etc. Now, defendants Denise Haggerty and Joshua Parkins are not here today, so they can be defaulted, and I can enter a default judgment against each of them at this time. I just need to do that with some testimony of Mr. Bontrager. So, Mr. Bontrager, please raise your right hand. Do you swear or affirm under pains and penalties of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
Okay, you may put your hand up. What is your full legal name?
Cecil J. Bontrager.
And Mr. Bontrager, did you at one time lease certain property to defendants Denise Haggerty and Joshua Parkins with a co-signer of defendant Daniel Adams?
Yes.
Okay, and did the parties breach that lease by not making the payments required of it?
Yes.
And did they also breach the lease by causing damage to the property?
Yes.
And what is the value of the rent, just the rent alone that is?
That is, just a minute here. $200 a week.
Okay, and what's the total amount of weeks and therefore, you know?
The total amount owed for just rent?
Just rent.
That is $22,000.
Okay, and then are there additional cleanup or repair costs that you
We had
incur?
a pet fee that wasn't paid for $1,650. That was $50 a month.
And how about the cleanup or repairs?
We're still trying to get the smell, but $1,340.
Okay, so you're up close to 25,000. You understand you filed in small claims court, so the
Understand.
maximum is 10,000?
Yes.
And you're willing to take a judgment of 10,000 against at least the two defendants, Denise
Yes.
Haggerty and Joshua Parkins?
Yes.
Okay, then I'll enter judgment in favor of the
I love
plaintiff
the name
and
Cecil.
against
so-
defendants Denise Haggerty and Joshua Parkins, jointly and severally. And then I would state for the record, if Mr. Bontrager approves this case, and if Mr. Adams does not come forth with adequate defenses at the trial, if Magistrate Burton entered a judgment, for example, of the maximum amount of $10,000 plus court costs, that would be joint and several, all three. In other words, Mr. Bontrager could not collect, 10,000 from each of the three defendants. That takes care of Ms. Haggerty and Mr. Parkins. Judgment's entered as of today, and you're free to pros up against them at any time. And then, Mr. Adams, I just want to make sure we have your correct information. Okay, the only address we had would have been the one from which at least two of the parties were evicted. Sir, what is your best address for receiving
My
those?
address is 636 Street, Bristol, Indiana, 46507.
Thank you for that. And sir, what is your date of birth?
5/28/1970.
Okay. And you have the option of having that trial notice and any other order getting mailed out to the street address,
Yes, sir.
or you could provide an email address if you prefer getting things by email.
I don't have an email. Just send it to the address.
Okay, I'll send it to the address. Make sure, so I can't vouch for the US mail these days. It takes sometimes 2 weeks to get something. Make sure you're proactive, use that sheet, check online,
Okay.
or call the clerk so that you don't miss your trial date. It's likely gonna be around a month from now, give or take.
Okay.
It's not over yet. I just have to tell you guys something real quick. Zach, I know you love this judge. That's why I get him. Only because of you. I don't like these kinds of hearings, so I never look at them. But you like this judge, so I watch this judge for you. So my son needs me to go pick him up right now, and I'm the mom. I could tell him to go to call his dad. No, I was kidding. So as soon as this is over, I'm gonna start the bench trial clip, and my daughter Tiffany is gonna take over for me while I go pick up my son. And yeah, and nobody watches judges for you, but I'm just telling you. Every time I play this judge, just know that the only reason I'm playing it is for you. Whether you even watch it or not, I don't care. As long as I have it there for you. I'm going to go pick up my son and come back. My daughter's going to be here. Monica, you guys are going to have to hold down the fort. I think you're the only two here right now, right? Kelly, are you here? No. So, and you guys are so good in chat though, so I'm not really worried, you know. But I'm gonna press play. We're gonna watch this together, and then I'm gonna leave and come back.
Any questions from either of you?
I just got one, if you don't mind. What can I bring, like, look, for my witness, like, for my credit? Because I don't have nobody stating or witnessing between me and my daughter and him that I did what I did. You know what I'm saying?
Okay.
I don't have nothing in defend me. You know what I'm saying?
You can submit any documents that you think would defend against plaintiff's claims or support your claims that you don't have liability. If you don't have any documents, you can give witness testimony as to why, or have others. So if you don't have exhibits, obviously you can't invent them, but you certainly can show up and testify and state your case, and Magistrate Burton will make a decision.
Okay, I appreciate it. I'm trying to be rude or anything, sir.
All right, I appreciate it. I know it's a frustrating situation. I just want you to understand that if Magistrate Burton finds there's a signed contract and you signed it, and you agreed to be a co-signer for them, even if it were their main responsibility, that doesn't relieve you from the obligation.
No, I understand.
But you're free to bring whatever evidence you like. And then Mr.
Just one question, yeah. I don't know that he will, but if he should decide to change his mind and not go to trial, what would the procedure be?
If the two of you gentlemen reach some agreement as to what is owed or what will be paid in satisfaction of what's owed, just let the court know perhaps a joint motion to dismiss and vacate trial would be appropriate. Again, if you receive payment and you're satisfied with it, whatever compromise amount, I leave that between you gentlemen. If you don't reach an agreement, the trial date won't be there.
Okay, thank you very much.
Okay.
Any other questions?
Really?
I wish you luck, sir.
Yeah, I wish me too. Thank you, sir. I mean, don't be respectful.
Thank you.
Well, you were. You just were. Okay, guys.
I have two.
Now I'm going to start this bench trial. And I just was enthralled the whole time. I think you're going to like it. When the defendant starts talking, after the officers testify and everything, then it's just awesome. It's just awesome sauce. So, let me start this trial, turn off my camera, and I'm going to jet and be right back. Hopefully, nothing goes wrong. What could go wrong, right? It's kind of, Colorado is kind of, I don't know. Okay, there's little pockets that are really good. One of the best judges on there, Zach, is Judge Fletcher. And he is down towards the bottom of the list. He might be Jefferson, so not at the bottom. But he's one of those judges that are like really good every once in a while. So it's a whole bunch of boring, and boom, this judge explodes, and it's awesome. But okay, we made it. I gotta go. I can't talk anymore. Good luck. I'll be back very soon. Be nice to my daughter.
Yes. We're here in cause number 2511 at 5305, State of Indiana versus Robert Lee Davis Jr. Good morning, Mr. Davis.
Good morning.
Matter set for bench trial today. Are the parties ready to proceed?
Yes, sir.
Very good. Let me pull this up real quick on my computer. It went to sleep on me from here. We have 4 counts on the docket today, correct?
Yes, sir.
Correct. Okay, count 1 is an F5 burglary. Count 2 is a criminal trespass, a misdemeanor. Count 3 is a trespass, a misdemeanor. And count 4 is possession of paraphernalia as a class C misdemeanor. All right, that being the status of things, would the parties like to give any opening remarks?
Wade, Your Honor, I do have one preliminary question for the court.
Go ahead.
There was the habitual criminal enhancement. I don't know when the court would. I know that it prerequisite is finding guilty on burglary counts the state has certified copies of prior convictions. I don't know when, if and when the court intends to take that file.
I think that'd be most appropriate at the end of the proceedings. So we'll do that then. And that was filed on 3/18/26. So while it's not another count per se, it's it's an enhancement. But okay. So with that being said, Mr. Kozlowski, were you okay also with cleaning opening remarks?
Your Honor, I'm actually want to give a brief overview.
Okay.
In this case, Your Honor, what we're talking about here and what the defense is going to focus on is largely about the specific intent of when my client entered the facility at Meijer. You'll hear his testimony as to why he was there, and you're not going to hear from any of the witnesses, I believe, of any indication of any actual theft. And I'll be happy to present case law in my closing argument with regard to kind of different ways that the courts have found are acceptable to prove that specific intent to commit a theft upon injury. So that's really where we're focusing our time here on this case. Thank you.
Thank you. State ready to proceed with the case in chief?
Yes, Your Honor. State House Christopher Settles.
Morning, sir.
Good morning.
You solemnly swear affirm and at least the truth, the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Go ahead and have a seat right there on my right. And speak yourself up as close to that microphone as you can. State, you may proceed.
Thank you, Your Honor. Could you please state your name and spell your last name?
Christopher Sells, Sells.
Mr. Sells, what do you do for a living?
I am overnight manager at the Meijer on Grape Road in Mishawaka.
That's Mishawaka, St. Joseph County.
Yes.
What are your general duties as the overnight manager?
I oversee the stocking team. I'm in charge of closing the store at night when we shut down at midnight. I lock the doors. I reopen in the morning at 6 a.m. I get the truck stocked when they show up. I deal with the vendors. Occasionally I have to make calls to law enforcement or to our regional oversight for things that happen.
I believe you said that the store closes at midnight and then reopens at 6 a.m. Is that correct?
That is correct.
Between those hours, should anyone from the public be inside the store?
Not at all.
How many public-facing doors does that Meijer location have?
They have a main entryway down by the pharmacy and one by produce.
Okay. You talked about locking the doors, is that correct?
That is correct.
Do you personally tend to lock the doors when the store closes?
Yes,
Is that with a key? Is it electronically? How do you lock them?
it is with the key.
And does the Meijer have a foyer with kind of two sets of doors?
Yes,
Are both sets of doors locked or just one?
just the outer doors.
Mr. Sells, I'd like to talk to you about November 4th of 2025. Were you working that evening?
Yes, I was.
Performing your usual duties that evening?
Yes,
And we had just discussed between 12 and 6 was the store closed.
yes, it was.
Had you locked that outer set of doors?
Yes,
Do you notice any issues with the lock or anything like that?
not at the time that it was locked. No.
For all intents and purposes, the door was locked?
Yes,
At any point, did someone come into the store while it was closed?
yes.
Do you know that person's name as you sit here today?
I do not recall the name. No.
Would you recognize that person if you saw them today?
Yes,
Is that person in this courtroom today?
yes, they are.
Can you point to that person and say something they're wearing?
Cream colored shirt.
Your Honor, may the record reflect the witnesses identified the defendant.
Record will so reflect.
So, Mr. Sells, At some point, the defendant was inside the store, is that correct?
That is correct.
Do you recall what time that was at?
It was around 5 o'clock in the morning. I don't recall the exact time.
Do you recall, at some point, did you come in contact with the defendant?
Yes.
Can you talk about how that came to be?
All right, so I was overseeing the team in a different part of the store when I received a phone call from someone up working in produce. They let me know that an individual had just forced their way into the store, at which point I went out to the front and I found the gentleman near the bathrooms. I told them that the store was closed to the public and that he had to leave. I repeated this multiple times. They did not leave. He argued that as he was already in the building, he didn't have to leave. At this point, I called law enforcement to have him removed.
Okay. So I want to wind back and talk about a couple of those things. So first and foremost, you met with the defendant, you told him he had to leave multiple times, correct?
Correct.
Did he ever leave after you told him to do so?
No.
Did the defendant have any, was the defendant pushing a shopping cart at that time?
There was a shopping cart, yes.
Was it a Meijer shopping cart?
Yes.
Did the defendant have any Meijer merchandise in the shopping cart that you noticed?
So the things that stand out to me are there was a bag of like water softener salt, and there was a orange bag that contained newspapers that we sell during the day.
That water salt, where is that typically kept?
It is kept on pallets outside the front doors.
Okay, so that'd be beyond the foyer and the two locked doors?
Yes, that's correct.
But that's Meijer property?
Yes.
Are you aware if the defendant any time had paid for or bought any water salts that day?
I am not aware.
And then the newspaper, do you know where that came from?
So that is dropped off in front of the building generally between midnight and 3 a.m. It gets dropped off.
Is that dropped off outside the two double doors?
Yes.
And again, that would be Meijer property?
Yes.
Had those newspapers even been put out for sale that day?
Not yet, no.
What was the defendant's demeanor like when you spoke with him?
Defensive, I guess would be the best way to say it.
Let me ask it a different way. Did he seem like he was in a normal frame of mind?
No.
You said you found him near the bathroom?
Yes.
At any point did he enter the bathroom?
Yes, he did.
Do you know what he was doing in there?
I myself did not enter the bathroom. However, when officers arrived, he was apparently taking off at least his shirt and washing up.
Again, the bathroom is on Meijer property.
That is correct.
It's maintained by Meijer.
Yes.
Did you personally call the police?
Yes, I did.
Did the police make the scene? Or did the police come to the store?
Correct. Yes.
Did you speak with them?
Yes, I did.
Did you ask them to remove the defendant from the property?
Yes, I did.
We talked about the salt and the newspaper. Did you recover those items?
Yes, we did.
Are you aware of any other items of Meijer property the defendant had on him?
Not that I can recall.
And this might have gone without saying, but did the defendant have permission to be inside of the store at that time?
No.
Did he have permission to take or use either the water salt or the newspapers?
No.
And to the best of your knowledge, he had not paid for either of those items?
Not that I am aware.
I pass the witness, Your Honor. Ross?
Hey, Garrett. So you said the Meijer store that you work at opens at 6 a.m., correct?
That is correct.
And this interaction with my client happened around like 5-ish a.m., you said?
Around then, yes.
Right. What time does the morning shift for Meijer usually arrive?
People arrive throughout the night.
Okay.
We have people showing up on the hour, midnight, 1 a.m., 2 a.m., 3 a.m., 4 a.m., 5 a.m.
Right. So it's kind of a stagger type thing then.
That is correct, yes.
Okay. And how do the reporting employees, how do they get into the store?
They call me, I come up, I let them in.
Okay. And in your experience, do employees ever let each other in? You said people working up at produce. If someone from produce saw someone coming, a fellow employee coming, would they let that employee in?
They are not supposed to. I cannot say for certain that they never do.
Okay. So you don't know, and they have the power to unlock those doors?
No.
Okay. So how would they unlock the door to let people in?
You do not need to physically unlock it to open it from the inside.
Okay. Okay, so you can, is it one of those deals where you can kind of push it over?
Yes, it's a push bar.
Okay. Do those push bars and those doors, do they ever kind of, if you open it, it doesn't close all the way, can you kind of, do you know what I mean? Like if it's open just a little crack, it's available to open up from the outside. Has that ever happened in your experience?
Only when the door is damaged.
Okay. And was the door damaged in this case?
Not at the time.
Okay. And by not at the time, what about after your interactions with my clients?
Afterwards, I did have to call in repair for the door. It had been shook loose to the point that it would no longer close.
Okay. So it had been shook loose. There was no like tool marks or anything on it though?
No.
Okay. No, I mean, so the main sign of forced entry was, like I said, shaking loose then.
Yes.
Okay. Now, you said the salt is kept outside the store, correct?
That is correct.
Now, those pallets, are they inside that foyer area or are they outside the store?
They are outside the store.
Okay, so fully outside, kind of in a place where anyone could just walk up to, right?
Yes.
Now, have you ever had people steal things from those outside pallets? I imagine that's
all the time.
Right. Do those people normally bring those items inside the store before taking them?
They bring them inside the store before purchasing them, not before stealing them.
Right. So someone in the middle of the night, they wouldn't then break into the door, bring the items in, and then take them back. You've never experienced something like that?
No.
Okay. Now, you said that the newspapers were in an orange bag while they were in the cart, correct?
Yes.
Is that the bag? Is that what the paper delivery person normally drops the
That is what they're delivered in.
So, by your estimation, it's likely, it seems that my client just picked up the orange bag and brought it in, correct? Whole cloth?
They picked up the bag and put it in the cart and brought the cart in with them.
Right, okay. Were any of the newspapers unwrapped or anything? Like,
not that I can recall.
Okay. And the salt bag wasn't opened or anything?
No.
All right. Did my client mention anything about the salt?
Not that I can recall.
What was his main kind of drive when he was talking about wanting to go into the bathroom or entering the bathroom? Because you said you saw him outside the bathroom, correct?
When I first arrived, he was outside the bathroom, standing near it.
Okay, so when you interacted with him outside the bathroom, what was his main goal? What was he interested in at that point? What was he saying?
As I recall, his only interest was being in the store. He did not have any particular things to say about the bathroom itself.
Mm-hmm. Did he mention anything about cleaning or being like, was the first time you became aware of any idea of cleaning, was that when you saw that he was washing himself and shirtless?
That is correct.
Okay. Did he say anything about the newspaper?
No.
Did you ask him anything about those things?
Did not ask him about it. I asked the officers to have it returned.
Okay, yeah. And my client didn't say anything about taking those things or wanting those things or needing those things or anything.
Not specifically, no.
Did he seem like he understood that the store was closed?
No. He was quite adamant that he had every right to be in there, and since he was already inside, he did not have to leave.
Okay. But did he make any threats or anything towards you? Was he hostile towards you?
No threats.
Right. So defensive, I think was the word that you used in the initial testimony, right?
Yes.
That he had a right to be there and he wasn't going to leave. And obviously, factually speaking, you disagreed with that as a manager who was responsible for opening the store, right?
Correct.
All right. No further questions.
Redirect.
Briefly, Mr. Sells, you said that before the defendant came into the store, you didn't note any damage to that exterior door. Is that right?
That is correct.
Afterward, you had noted some damage.
That is correct.
And as far as you knew, before the defendant came into the store, the door was locked and there were no issues with the locking mechanism. Is that fair?
Yes.
To the best of your knowledge, did anyone let the defendant into the store that evening?
No, they did not.
No further questions.
Any re-cross, sir?
Have you talked about any of your employees if they let him in?
I talked to several employees who saw the gentleman come in the building.
Right.
And I talked to the ones who originally called me about it,
Right.
who had heard the banging as he was shaking the door open.
Understood. No further questions.
I have just a couple questions, sir. The newspapers, were those the papers for that day, 11/4?
Yes, that is correct.
Okay. And when you're talking about the bathroom, was that the bathroom in the foyer kind of area between those two sets of doors?
No, those are the doors down on the pharmacy side. He entered on the grocery side. The bathroom we're discussing is up in front of the cash registers.
In the middle of the store, kind of in the front?
Yes.
Okay. Those questions prompted the questions by either of the parties.
Defense has one, but I think the state gets go first. Yeah.
And I believe I asked this already, Mr. Stells, but Meijer maintains that bathroom, keeps it stocked and pays for the water and things like that.
Correct.
Nothing further.
Mr. Kozlowski.
Just one question. So, have you ever worked as a day employee at Meijer, like when shoppers are there normally, or have you only been nighttime?
Oh, I've been there during the day.
Okay, so is it in your experience, do customers often, if they're going to get something from outside, like the salt, get it and put it in the cart and bring it in?
Not frequently.
Mhm.
There are means of selecting to pay for the bags at the registers.
Right,
They generally don't get the bags first.
right, but it happens.
It does happen.
And in your experience, do shoppers sometimes use the restroom when they come into the store before they finish the rest of their shopping?
Yes.
No further question.
Thank you, sir. Is the gentleman released from his subpoena?
Yes, Your Honor.
Thank you, Mr. Sells.
State next calls Jeremy.
Morning, sir.
Morning.
Solemnly swear or affirm under penalty of perjury and testimony about it. Give us the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
And it's right there.
Morning, sir. If you please state your name and spell your last name.
Yeah, my name is Jeremy Coney. So Coney.
Sir, so you're wearing a uniform. Are you a police officer?
Yes, with the Mishawaka Police Department.
How long have you been doing that?
I've been with Mishawaka for 2 years, and I was previously with the Elkhart County Sheriff's Office for 4.
Sir, I'd like to talk to you about November 4th of 2025. Were you working that day?
Yes,
What shift were you from?
the midnight shift,
Is that, what hours is that?
6:30 p.m. to 6:30 a.m.
At some point during that evening, were you dispatched to the Meijer located at 5020 Drake Road?
Yes,
And that's here in Mishawaka, St. Joseph County?
yes.
Where were you dispatched to for?
It was an unwanted person call.
Do you recall what time you were dispatched there?
Dispatch probably 4:30-ish. Close to that.
Did you make the scene?
Yeah, about 4:38-ish. I arrived at my.
When you made the scene, did you meet with any store employees?
Yeah, there was one waiting for me at the door who held the door open for me. I don't recall his name, and then the store manager or some sort of management at the Meijer.
You say that the first person held the door open for you?
Yeah.
Did they indicate if there was anyone unwanted on the property?
Yeah, the manager I talked to, I believe, was the caller who said that there's a male in the restroom that was not supposed to be there as they weren't open yet.
Did you go over to the restroom?
Yeah, I entered the men's restroom that was on the south side of the building.
Did you find a person inside?
Yeah.
Do you know that person's name today?
Robert Davis.
Would you recognize Robert Davis if you saw him?
Yes.
Is he in his courtroom today?
Yes.
Can you say something he's wearing?
Looks to be some sort of jail uniform.
May the record reflect witnesses identified the defendant.
The record will so reflect.
Mr. Coney, in your training experience as a law enforcement officer, have you ever dealt with someone who was under the influence of either alcohol or drugs or other substances?
Yes.
Are there typical kind of signs or indicators that someone is under the influence?
Yeah, it all depends on which drug, obviously. But common side effects, do you want to call that, are saying stuff that doesn't make sense, high energy, doing strange things that people don't normally do.
Was Mr. Davis exhibiting any of those indicators when you met with him that day?
Yeah. So obviously it was 4:30, 4:40-ish a.m. and the Meijer didn't open till 6, I believe. Somehow he got into the restroom and he was standing in there with his shirt off.
Was he saying any nonsensical things?
Yeah, a lot of strange things that didn't make any sense. There's no kind of logical continuation of his speech in reference to what I was saying to him. None of it really made sense. Yeah.
At the time, did it appear that the defendant was under the influence of some sort of illicit substance?
Yes.
What was the defendant doing? Like, what physical actions was he doing in the restroom?
Yeah, it looked like he was attempting to wash his shirt in the sink, the bathroom sink.
Did he have any property with him, so bags, shopping cart, anything like that?
Yeah, he had a shopping cart in there. I think he had a lot of, I think there's like some paperwork, a folder. He had a bag. It was like an Aldi bag. I think there's a bag of salt, like the water softener salt in the cart, and a newspaper and like an orange, newspaper bag is what comes to mind specifically.
Are you aware if any of that property belonged to Meijer?
Is my understanding the newspaper and the bag of salt would have been Meijer's.
Did you or other officers return that to Meijer?
Yes.
Now, at some point, did you tell the defendant that he had to leave the property?
Yeah. As soon as I made contact with him in the bathroom, I told him multiple times, I would say at least 6 times that he needed to leave. I specifically told him he wasn't wanted here, that he needed to leave, that the store wasn't even open.
At some point, did he exit the store on Meijer property?
Yes.
Was that after coaxing by you or other officers?
Yeah, it's a pretty heavy coaxing to get him out. Had to plead with him for a while in the bathroom. Finally just kind of pushing the cart out the door, kind of triggered something in him to finally understand what we were trying to get him to do and then leave the bathroom. As we were in the store, he got stuck at the front door because of I think Meijer has that wheel locking technology on the carts. So if it hits a certain line, it'll lock the wheel so he can't leave. So at that point, he got distracted, started talking a lot of nonsensical things again. We had to coax him to get his stuff out of the cart, give back the newspaper and the salt. Once he finally got his stuff packed into that Aldi bag, he then finally exited the Meijer store.
And he took that bag with him?
Yes.
Now, did you tell him to exit the full property of Meijer at any point?
Yeah, on the way out, we got stuck again between the two doors. And I believe the manager was standing to my left inside the two doors. And we got him finally out the second set of doors. And I looked at the manager, I said, do you want to leave the parking lot completely? And he said, yes, please. I said, yes. So then I followed him out the door, the second set of doors, told him again, you need to leave. I told him specifically go out to the road and to go north-south, just leave the Meijer parking lot. You can't be here. You're not wanted. You could trespass.
You specifically instructed him to leave the property entirely?
Yes.
All right. Did he completely leave the property?
No.
Did you give him any warnings about if you don't leave, you'll be arrested?
Multiple. Again, he kept turning around and talking to me. Wanted to say stuff that didn't make sense. So I kind of walked with him, trying to force him off the property. I mean, not physically, but help him understand he needed to leave. We got, probably another 100 or 200 feet towards the west side of the parking lot. He was still on Meijer property. I gave him his final warning. So I'm going to walk back to my patrol car, which was in front of the Meijer. So if I get there and I turn around, you're still on the property, I'm going to come over here and arrest you for trespassing. So that's what I did. Walk back to my patrol car and saw he's still on Meijer property. So I went and arrested.
You arrested him. Did you transfer him to the St. Joseph County Jail?
Yes.
At the jail, do you know if jail staff performed any inventory or looked for his property?
Yeah, it's standard procedure.
Did that include that blue Aldi bag?
Yes.
Are you aware if anything was located within that blue Aldi bag?
Yes, the CO that was working, correctional officer, alerted to me to a glass pipe that he had found in the bag.
Did you take custody of that glass pipe?
Yes.
Here, may I approach the witness?
May.
Sir, I'm handing you what's been marked as State's Exhibit 1. If you can take a look at this and look up at me when you're done. We were just talking about a glass pipe, is that correct?
Yes.
Is that pipe, is what I just handed you the pipe in question?
Yes.
Did you package that pipe after the incident?
Yes.
Is the pipe today in the same or substantially the same condition as when you packaged it?
Yes.
Here in the state would move to admit and publish to the court at an appropriate time. It's been marked as State's Exhibit 1.
Any objection, Mr. Kozlowski?
No objection, Your Honor. Thank you.
Thank you. Then it is admitted, maybe published at your convenience, sir.
Officer Coney, in your training experience, have you dealt with items that appeared to be used to ingest illegal substances?
Yes.
Are glass pipes one of those types of items?
Yes, a very common one.
What indicators do you look for to determine if an item has been used to ingest illegal substances?
Usually the burnt black residue on the ends that would usually indicate some sort of heat source to light the pipe so that they could smoke it.
The pipe that I handed you, are there any indicators that have been used to ingest illicit substances?
Yeah, so there's some black residue inside the pipe.
Again, that's a common indicator.
Yes.
Did you leave Mr. Davis, the defendant, in custody of jail staff that evening?
Yes, I did.
Pass the witness, Your Honor.
Cross-examination.
Thank you, Your Honor. Officer Coney, when you were speaking with Mr. Davis while he was in the bathroom, you said he was speaking nonsense, correct? Mm-hmm. There wasn't a lot of logical flow to it. No. Just to pick out some things, was he talking about Bible verses at all, by any chance?
Yes.
Yeah. Was he talking about cleanliness at all, by any chance?
Yes.
Did that seem to be a bit of a fixation for him at the moment?
Yes.
And did he indicate anything about the salt to you?
Not that I recall.
Okay. Did he indicate anything about the newspaper to you?
Not that I recall.
So let me walk through kind of what happened. So you make the scene, you speak with the manager, you go to the bathroom. So You start talking with Mr. Davis in the bathroom, right?
Correct.
What's your first course of action?
I asked him to leave.
All right. And he is speaking nonsense for some time then. There's back and forth between you and he. At what point does he leave the bathroom?
It took a couple minutes. I can't say exactly time frame. I would say anywhere from 5 to 10 minutes.
Was there anything that shook the situation loose a little bit, that got him to kind of move? Is there anything you said or someone else said that kind of got through to him and he left the bathroom?
The only thing that comes to mind is when I finally stepped in further into the bathroom and actually pushed the cart, which had this property in it.
Okay, so at that point, you grabbed the cart. You pushed the cart.
Yeah.
Did you remove it from the bathroom?
I started pushing out of the bathroom. Yes.
Okay. Now you start pushing out of the bathroom. What did my client do when you were pushing it out of the bathroom?
He followed with the cart.
Okay, so you followed along and you were pushing the cart.
How many people did she ban? I'm telling you, that one that you guys were with, you wouldn't want to mess with her. She'll just, she loves banning people. She loves it. And she loves yelling at people. Did she yell at anybody? Did she verbally abuse anybody? Because she would be the one to do it. Thank you, guys, for letting me go get my son. Hope everything went well.
And where did you go from that bathroom area? Like, walk us through. So if you come out of the bathroom, I may approach thank you. So you come out, and there's kind of two entrances on either side. There's one over by the pharmacy and one by the produce, right?
Correct.
All right. Which direction did you go?
Left.
Okay. So you push the cart and turn left, and he is following behind you, on the side of you. Where is he at?
I'm sorry. When I said push the car, I kind of grabbed the edge and just shoved it and turned it.
Okay.
From my recollection, he himself took over and then pushed the car himself.
Okay. So where were you at while he was pushing the cart?
Standing behind it.
Standing behind him. Okay. And so he's kind of pushing the cart under your supervision, right?
Correct.
Now, you're not going to let him go. You're not going to let him walk off with the salt, right?
Correct.
And he knows you're a cop, right?
Yeah.
Right. So you're walking and you're still talking, right? The whole time he's kind of going. And are there other officers that are walking along with you all?
I have one officer.
One other officer. Okay. So on each side, I'm assuming you probably have someone right there on him.
Mhm.
Right. So you guys are walking towards the entrance. When you get towards that entrance, right there where they have the mats out in front of the produce there, and you have the kind of those little scanner things. I don't know what they're called, but the shoplifting things.
Yep.
What happens when you guys get to those?
The cart locked.
The cart locked. Okay, so at that point, the cart locked up.
The bottom of his shoes were red. Did you see that? That was pretty cool. We're gonna hear him testify soon, and it's epic. It's so good.
Was that before? Like, where was that at exactly when the wheels locked up?
It went right between those. What you described.
The little scanner thing. Okay. All right. Is there any reason why you didn't take the merchandise out of the cart at any point?
I didn't know the status of it.
Right.
I didn't know if he had paid, which I assumed not.
Right.
It wasn't open yet. I didn't know if it was from Meijer or not.
Yeah.
Because salt in the newspaper is pretty common.
Yeah.
So it wasn't until I think the manager that was behind this alerted to us that was for Meijer's property and it hadn't been paid for yet.
Okay. All right. So did he appreciate that you were police officers? Like, did he acknowledge that you were police officers?
I think from his rambles, I would assume so because he was mentioning jail. So I assume that meant he realized we were police. So,
Right. Okay.
So yes.
And did he express any ownership over the salt? This is my salt. These are my papers.
What is a Meijer, by the way, guys? I'm guessing like a discount, sort of smaller Walmart type store. Is that about right?
Anything like that?
I don't recall.
Okay. And when did he seem like he wanted to take them with him at any point?
I can't say he explicitly said, I want to take the salt, but he was grabbing the cart trying to pull it out of the store.
Okay. And that was while you were telling him to leave the store, kind of guiding him there without taking the cart from him, right?
Correct.
All right. Well, in your experience, have you ever dealt with shoplifting cases?
Yes.
How often have you seen someone take items that are positioned outside of a store into the store before then stealing them?
None that I can recall.
So uncommon though.
Correct.
No problem.
Any further from the state?
Mr. Coney, you said that you were in the restroom with the defendant for at least a couple minutes. Is that correct?
Yes.
Was the defendant using the facilities while you were in there?
Not in a traditional way.
What untraditional way was he using them?
The first time he took off his white shirt and he rinsed it out of the sink, put it back on. Then he grabbed a second shirt, rinsed it again. So, trying to wash clothes with the sink, I guess.
You said that you grabbed the cart, but the defendant was pushing it toward the door.
Yeah, so when I got in there, I grabbed it and kind of shoved it towards the door, let go of it, try to get him to get and go, because he wasn't listening, he wasn't going. So once I kind of shoved it, we recognized that I was trying to get him to leave. It was like, that'll be my understanding. And then he took over and kind of pushed it. I think the other officer kind of grabbed it, pulled it out of the bathroom, and then Mr. Davis followed behind it and pushed it himself out.
So the wheels locked up when he hit the scanners at the door.
Yeah.
Do you recall if the newspapers or the salt was still in the cart at that time?
I'm sure the salt was, because it's so heavy. He wouldn't have been carrying it. He may have had the newspaper in his hand, but I can't say for certain.
I'm glad you're working hard.
One on recross, Your Honor. So when you grabbed onto the cart, was he touching the cart in any way?
Originally in the bathroom, when I tried to push it towards the door, I don't recall if he was. Don't think he was.
Was he washing his stuff at that point?
Look, if we had to do what Brent had to do, we would rest whenever we could as well. With rum.
Or were you just talking at that point?
Probably, I don't think he was washing at that point. I think we were just talking, trying to reason with him to get out.
Right. Okay. No further questions.
You done the release from the subpoena?
Yes.
No objection, sir.
Maybe come by this, but you were really going today. Unless you're on the state calls show clubs.
Morning, sir.
Good morning.
You solemnly swear or affirm under penalties of perjury, the testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Go ahead and have a seat right there, sir.
We should do a Court Vibes doggy calendar with Jack and Louie on the front cover.
I apologize, Your Honor. There's a piece of paper I need to give back to Mr. Coney. I'll be right back.
Well, I understand.
He does, Monica. Just turn him around.
Sir, can you please state your name and spell your last name?
And it's Joseph Colmus, Kolmos.
Mr. Comas, I see you're wearing a uniform. Where are you employed?
I'm a deputy at St. Joseph County Jail, booking officer.
How long have you been doing that?
I've been working at the jail since August of 2024.
What are your general duties as a booking officer?
Process new intakes that police officers bring into the jail when they arrest them. The processing can include inventory.
So, what did he allegedly steal? Sort of nothing. Okay? On the way into the store, he grabbed a bag of salt. One of those big bags that they have out front. He put it on a cart, and then he came into the store with it. Also on the way into the store, he grabbed a bundle of newspapers. So it was like in the armpit of the morning. Like the sun isn't up yet. It's like 4 a.m. And the newspapers were just delivered in a bundle. So he grabbed the bundle and he put that in his cart too, to bring it into the store. Now, he didn't. There's also one more thing that they claim he allegedly stole. He went into the bathroom and took off his shirt and was washing his shirt. So they claimed he stole the water in the bathroom.
Property, to include clothing that people are wearing when they come in, any possessions that they come into the jail with, searching for any suspected contraband. And then once that is complete, changing their clothes out and getting them into the computer system, adding charges, trying to schedule a court date.
Sir, were you working on November 4th of 2025?
I was.
At some point, did you help with the intake of a detainee named Robert Lee Davis?
I did.
Mr. Davis in his courtroom today.
He is.
You just point to him and say something he's wearing.
He's wearing a white shirt.
Sir? Was Mr. Davis brought in by Mishawaka police officers?
Yes, that's correct.
Did the Mishawaka police officers bring any personal property with Mr. Davis?
They did. I recall 2 bags of property being brought along with Mr. Davis.
Did you help inventory that property?
I did do the inventory of that property.
In the process of that, did you locate, Your Honor, may I approach the witness?
You may.
Sir, I'm handing you what was previously admitted and marked as State's Exhibit 1. In the process of inventory of Mr. Davis' property, did you locate what's been marked as State's Exhibit 1?
I did.
In your time as a booking officer, have you located other similar pipes or objects on other people?
I have numerous times.
What a horrible
Based
thing
on your
to
training
say.
experience, did that appear to be used to ingest illegal substances?
Yes, that is what we call a crack pipe, is the street term for it.
What makes you believe that it was used to ingest illegal substances?
There's a burned residue on one end of the pipe, which is typically where an illegal substance is lit on fire so that it can be small.
Did you hand that item over to a Mishawaka police officer?
I did.
Sir, when the defendant was brought in for booking, did he appear in a normal frame of mind?
He did not.
What made him appear in an abnormal frame of mind?
He had a 1,000-yard stare. He was reciting Bible verses from memory at a very high volume. He was unable to answer questions that people would ask him. It's like he wasn't even in the same room as you.
Have you dealt with, in your training experience, have you dealt with people who were under the influence of illegal substances?
I have.
Did Mr. Davis appear to be under the influence of illegal substances that evening?
He did.
That's the witness, Your Honor.
Cross?
Did my client at any point say anything about any assault or any newspapers or anything?
No,
Just reciting Bible verses?
that's correct. So
Do you remember what they were?
I do not, sir. I'm not a religious man.
Fair enough. Was he talking about cleanliness at all?
I do not recall.
No further questions.
Any redirect on that?
No, Your Honor.
Is the gentleman released from the subpoena?
Yes, Your Honor.
Thank you, sir. You're free to go.
Thank you.
Like what's the deal?
Thanks. Stay rest, Your Honor.
So, Mr. Davis, there's a lot of decisions that your attorney needs to make about tactics and things for a trial, but we're at the point where one of the decisions that you have to make as the defendant, we're at that point in the game, and that decision is whether or not you would elect to testify on your own behalf. It's a decision that you and only you can make, but it's a decision you should make after you consult with your attorney and after you guys, he talks about the pros and the cons and gives you his professional opinion on it, okay? So what we're going to do is we're going to take a 5-minute break. We're all going to leave court except for you and security and your attorney. and you're gonna have that conversation. I'll come back in and ask you how you feel about that, okay?
You don't need to go to the courtroom. We can take a recess, of course, obviously, but you don't need to go to the courtroom. We're ready to roll.
You've already had that conversation?
See that? See that? Public defenders, they work hard. They just do. He's ready. He's already had the conversation with his client. He's pretty passionate about this case. I mean, he's doing a really great job. But it's about to get really good, guys.
We're prepped and ready to roll.
Okay. And is the decision that you've made, you're comfortable with it being your decision, Mr. Davis?
Absolutely.
Okay. Very good. And if you already know, Mr. Kozlowski, this is the defense intend to put on a case.
Defense will call Robert Davis.
Okay. Very good. Yep, yes, sir. Before you get to Mr. Davis, as best you can, you promise to tell the whole truth and nothing but the truth, so help you God. So help you God. Okay. Go ahead and make your way over there. Don't run.
Don't run. No one has ever had to say that to me.
You're close to that microphone so we can hear you pretty well. Okay, sir. And Mr. Kozlowski, you may proceed.
Thank you, Mr. Davis. We already have your name here in the record, but I want to take you back to the night in question. Do you remember the night that we've been talking about here in court on November 4th of 2025?
Yes, I do.
Okay. So I want to take you back to November 3rd, or in the evening of November 3rd. Where were you at around that time?
I was at a friend's house.
Okay, and what was that friend's name?
His name's Glenn.
Okay. And what were you doing in Glenn's house?
I was reading the Bible.
Okay, was there anything in particular you were reading?
Yeah, I was reading Ezekiel.
Okay.
It was and it was saying something about how the people can't discern what is clean and what is not clean. And I got freaked out because I knew that I was supposed to be clean and I wanted to be clean.
Right. Now, when this happened, what did you do after that? After you read that?
I washed everything that I had and I put mittens on my feet because I couldn't wash my shoes.
Now by mittens, you mean those little
big mittens, the ones that supposed to go on your hands. They were knitting. They were knit.
Right.
So they were big enough to go on my feet because I was able to wash them and also put them on and have everything on me clean.
Right on. And then after you cleaned your things, what did you do next?
I left and I went outside. And
why did you leave the Glad's house?
Because I didn't want to be around anything that could have been.
And was there something in particular? And I'm sorry to kind of put you on the spot here with someone in the audience, but was there something about Glenn's house that made you?
It was just clustered.
Right.
And it caused me it causes me errors sometimes.
Yeah. So it was dirty, or in your mind at that time.
Yes.
Okay. And so about what?
I'm very turned on right now. This man loves to clean. Is that what he says? Is that the vibe you're getting, that he loves to clean? He has to, not loves it, he has to clean something that's dirty. He has to. I need him to come over to my house for a bit. We can just sit over a cup of coffee and talk, and then whatever happens, happens.
What time was this that you left? You remember?
Yeah, it had to be like, I'm going to say between noon and 3 or 4.
Noon and 3 or 4. So sometime in the afternoon on the 3rd.
Yeah.
Okay. And where did you go?
I went into the woods. Because there's a stream of water that is near there, and I enjoy it. Okay.
Right. So let me narrow this down. Where were those woods at? Can you describe them relative to other locations?
So those woods also connect to across the street from Meijer, so you can visit.
Across Grape Road?
Yeah.
And you've gone to that place before?
Oh, many times. I spent many hours there.
Right.
Yeah.
And what do you normally do there?
I normally just kind of lollygag.
Mm-hmm.
Yeah, I enjoy it. I'm in jail a lot, and I enjoy it very much, and it is my release, and I tend to go there so that I don't sin, so that I don't do something that I don't want to,
right.
Something that in my eyes cannot be good,
So did you bring anything with you to those woods?
Yes, I brought a bag with some Bibles in it and a dictionary and some notebooks.
Okay. And you stayed there for throughout that afternoon and evening, correct?
Oh, yeah.
All right. Did you end up leaving those woods?
I did.
About what time?
About the time I realized I needed to get out of the home.
Okay, and what was that?
Maybe like it was dark already for a while because I was working out in them too. I was doing some burpees. I was exercising because I've been in the jail, and that's what I've been doing in the jail, and I wanted to continue that.
Right. So about what time?
About 11:30.
Okay.
Maybe it was many hours dark already. Well, yeah, it was reasonably dark.
All right. So it was in the nighttime.
It was in the nighttime.
All right.
Yeah, I can't give you exact numbers.
So where did you go when you left those?
I went to Meijer to talk to people again.
Okay. And when you got to Meijer, what happened when you went to Meijer?
Well, I went inside and I went right where, right. I didn't go in like all the way in the store or nothing like that. I wasn't paying attention to that. I just wanted to be around people.
Right. And by right inside the store, do you mean like the foyer that's right in when you come in?
Past that, but right where the automatic registers are, where the self-service.
All right. And what happened when you went in at that point?
I talked to the workers that were there.
Yeah, and what happened after you talked to the workers?
Well, I think the time for they said that I needed to leave.
Okay. And why was that?
I think they were closing.
Okay, so they were closing at that time, right? And what did you do after they told you that they were closing?
I left.
All right. And where did you go at that point?
I went along the front of the store and then to another set of wooded area, and I relaxed there for a while.
Okay. Now, so you went out and around the store. So you went to the back of the store. Am I understanding that correctly?
Yeah, because there's there's also a big thing of water there, and I enjoy the water. I enjoy water tremendously. There's like a big pond of water there.
So you're talking about back between the Meijer and the car dealership and those like little fast food places.
There's a big pond back there,
Okay.
nature, and so I spent some time back there.
And you still had your stuff on you at that point, right?
Yeah.
Okay. And did you stay in the woods? Like when did you leave?
When I realized that I was being silly and I needed to get moving again.
Okay. Because it had how long had it been?
It could have been hours.
Right.
It was some time. I was.
Was it still dark out at that?
Oh yeah.
Okay.
Yeah.
So what did you do when you left those places?
Well, I went to walk through them and then down and then.
By down, what do you mean?
So it's like there's like a valley, okay? And then there's the big pond after the valley, and I'm beside the pond, and then I'm walking, and then my feet start sinking a little bit.
Right. Oh, because the ground is flat.
Yeah. Well, the ground was getting soggy there.
Okay.
It was soggy, and then I had to turn around and.
Because you didn't want to.
Yeah. Right. I didn't have shoes or nothing on. Yeah.
All right. So when you turn around, you mean you turn around back towards the forest and back towards Meijer?
Yes.
Okay. And where did you go after that?
I walked back around the same way that I went, and I got sidetracked a little bit. There was like a scissor lift, and it just because there was a word on it or something that excited me, but I didn't want to mess with it because
let's slow down a little bit. So when you saw the scissor lift, you said that excited you.
Yeah.
Now, Robert, I'm going to ask you a question here. Were you intoxicated?
I was
Sir, you do not have to be intoxicated to get excited over a scissor lift.
stimulated. Yeah.
Robert, were you intoxicated?
Yes.
Okay. Thank you. And so you were kind of in that heightened state that comes from being intoxicated, right?
Yes.
And so you said, to go back to that, you said that something about the scissor lift kind of tickled you, I guess.
Yeah, it was a number actually on it.
Okay. But you backed off, you didn't touch it. What did you do after that?
And then I walked in front of the store. I kept on walking and,
Just listen to what he says. The lawyer's going to pull it all together in his closing statement.
I was probably taking my time even because I tend to do that. And then I got towards where I normally stand and read my Bible. I usually stand and I'll spend a lot of time right there by the salt a lot because it I don't know, it makes me.
Because we all read our Bibles by the rock salt. That's normal, right?
Think of clean things.
Yeah.
Especially because all the words that are on it,
Right.
It's like clean, and I was already in a state of mind of wanting to be so clean, because I was fearing God and everybody possible.
So while you're by those bags of salt, was there something about the salt bags that drew your attention? I know you mentioned something about cleaning, but this particular time.
Yeah, because it said action on it. It said action in a big word, and then it was cleaning, and the only thing I could think of was it was time to make sure that I was clean again.
And what did you do after you kind of saw that and kind of processed it?
I got excited. I know that I got excited, and I think I waited a while because, and then I didn't know what to do. I didn't really know what to do.
Okay. So what did you do kind of after you sat down and tried to calm yourself, I guess, for like a better term?
Well, I think I went and tried the door.
Okay. And yeah, you went and tried the door.
I tried the door, yeah.
And at that point,
Excuse me, he might clean your house for you. Isn't that a bonus? Isn't that a good thing? I mean, it's better than inviting people over that just make a huge mess.
did you get into the store?
Yeah,
Okay.
yeah.
Now, did you have the salt with you at that time?
I don't think I did.
Okay.
No, because I think I put the salt on the cart once I think I opened the door because I wanted to use the salt to I guess to help me also maintain a mental prompt, and I guess to give them a reason why I did what I was doing. I wanted to tell them about why, about the salt and about, the action and then the cleaning, and I was, and then, of course, the newspaper.
Hold on. Let's slow down. All right. So you open the door and then you believe you put the salt into the cart.
Yeah.
Okay.
Yeah. Or on the cart. I didn't put it in the cart.
On the cart.
Yeah.
All right.
So I could see it. Yeah.
All right. And then you mentioned something about a newspaper.
Yeah.
Walk me through what you mentioned something about a newspaper.
Yes, the newspaper was there. I saw the newsman bring it, and I wanted to give it to them.
Okay.
Because I wanted to be polite, and I'm crossing as something that they had
No, Mommy, I stole this cookie for you. I wasn't going to eat it.
to do, and it was simply to give it to them.
Okay.
Yeah.
So when you went into the store and you had the salt in the newspaper, either on the cart or in the cart, what happened next?
Well, I went towards the bathroom, and then the guy, he said something to me, but I can't really. I mean, I'm sure he told me I had to go. I mean, that's obvious. That's probably what he said. But I don't think I've registered it too much because I wanted to go clean up so that I would be more presentable, and maybe he would be not frightened of my crazy hair or something, because my hair get kind of crazy sometimes.
Was that because you had been out in the woods?
Right. Yeah.
For about a day?
And yes. Yeah. That's exactly.
Objection
right.
leading.
Fair enough. And when you when he tried to stop you, you didn't kind of leave. You didn't leave the store at that point, right?
No.
Right.
I wanted to finish. But
Yeah.
that word action.
So what did you do next?
I went to the bathroom.
Okay. And what did you do in the bathroom?
I washed my face and hands.
Okay. And did you do anything else in the bathroom?
Not that I can. No, I did not.
Okay.
No.
And did you encounter law enforcement while you were in the bathroom?
Yeah, and they scared me. Yeah.
What happened after you encountered the law enforcement officers?
I think my heart went about 1,000 miles an hour because I'm like, oh no, jail again. Why did I do this? Oh no,
Right.
No, I didn't mean to do that. I didn't mean to cause problems again.
Yeah.
I kind of got freaked out a little bit,
Okay. And did you eventually start to leave the store?
Yeah, because I wanted to obey the officer. Yeah.
Okay. Now at that point, you leave the store. Were you at all intending to keep that salt or those newspapers?
No, not at all. I didn't. No, I wanted to give the newspaper to them, and I wanted to use the salt as a prompt.
To do essentially your kind of street preaching that you talked about.
Yeah, absolutely.
Okay. And when you left the store, did the officer follow you out of the store?
Yeah.
What happened after you and the officer left the store?
Well, he told me if I would come back to the store that I would be arrested for trespassing.
Okay. And so what did you do after that?
I easily left. I was easily leaving out of the park.
Now you were leaving, but did something else happen?
Yeah. I had a long robe on that was too long, and I had a heavy bag, and I was tripping over it. So I had stopped, turned towards the officer so that he could see that I was tucking it in.
Okay.
Because it was 4 inches longer than I am tall.
Yeah. Because in your experience, Mr. Davis, you don't necessarily want to put your hands into your pockets of your pants while there's law enforcement around, correct?
No, not at all. And I wanted him to see that I was trying to just be safer because it's dark out and there's, and I had to walk on the street,
Right.
So I wanted to be more secured,
Yeah. And you ended up getting arrested.
I did, yeah.
All right. No further questions, Your Honor.
State Cross.
Yes, Your Honor. So first and foremost, Mr. Davis, you've been in the courtroom and everyone else is testifying, right?
Yes,
You heard Mr. Sells talk about how they lock the doors at night, correct?
yes,
You heard him say that, you know, as far as he knows, the doors were locked the night when you came in, correct?
yes,
He had said that before you came in, the doors didn't appear damaged, and afterward they did appear damaged, correct?
yes,
You heard him say that he had told you to leave, and that at that point you hadn't left, correct?
yes,
You heard Officer Coney say that he had told you to leave and it took a while to get you to leave, correct?
yes,
And it's your testimony that you did have the salt and the newspapers in the cart when you were in the store, correct?
yes,
And you admit that those are Meijer property, correct?
yes,
And you had them in your possession inside the store, correct? So you were pushing a shopping cart, correct?
yes,
Okay. The salt was on the shopping cart, correct?
yes.
So you could have pushed the salt around the store in the cart, correct? If
No,
you
I
want.
wasn't pushing salt around the store, no.
Okay. But it was in the cart, you were pushing the cart, correct?
Yes,
Officers took you to jail, correct?
Yes.
They found State's Exhibit 1, this pipe in your bag, correct?
yes,
And, you know, Mr. Kozlowski had asked you, you admit that you were under the influence that evening. Is that fair to say?
yes,
You had taken whatever substance it was yourself, no one forced you to take it, correct?
yes,
And is it fair to say you were in kind of an altered state of mind than, you know, how you are today?
yes,
Now, Mr. Davis, inside the store you were using their facilities, correct?
yes,
Those facilities are maintained by Meijer, correct?
yes,
You were using Meijer's water, correct?
yes,
And it's your testimony that you hadn't intended to use the salt. Is that what you're saying, sir?
no, absolutely not, no, I have no purpose for the salt, but the one that was on.
It's your testimony that those newspapers you intended to give to the store personnel.
Absolutely,
You heard Mr. Sells earlier testify again, yes?
yes,
He testified that when he spoke with you, whatever it was you were saying, it sounded like it didn't make a whole lot of sense to Mr. Sells. Is that correct?
yes,
So it sounds like, based on Mr. Sells' testimony, you never.
Yeah, but in his defense, people say that to me all the time. And I'm not crazy, and I didn't break the law.
Or offered the newspaper to him at that time. Is that correct?
yeah, it was a very short amount of time,
At
that I wanted to be clean.
any point before the police kicked you out, did you offer to hand those newspapers over to the store personnel?
No, I was too busy being confronted.
And you were in, what was the word you used? I don't believe it, you were in a stimulated state, correct?
Yeah,
And you recognize, you know, today, Mr. Davis, that the property that you had, none of the salt and the newspaper, those didn't belong to you, correct? Davis, you have a prior conviction for, forgive me, I'm pulling my book right now, for theft out of the St. Joseph County Superior Courts in cause number 71 DO6 2401 CM 98 from February 22nd of 2024. Is that correct?
yes,
You admit that that is a crime of dishonesty?
No, I believe,
And yeah, I'm gonna object to that. That's the legal basis that these are entered in, asking the witness as to whether or not that's a crime of dishonesty. I don't think that's something he can testify to. Again, that's a legal standard, not a factual issue.
I think that's correct.
Sustained. Thank you.
It's a legal determination.
No, sir. That's the witness background. Can you read rec, sir?
Just one. Mr. Davis, did you decide to clean yourself before or after you entered Meijer?
when I entered.
Okay,
Oh.
so after you entered, then you decided to go clean
No,
yourself?
no, the whole thing was to clean myself.
Okay.
Well, the bag of salt was, I was already in the state of mind of needing to be clean, or wanting to be clean, desiring to be clean, needed to be clean, like fearing God, have to clean. And the bag of salt with the word action on it, and it was the biggest word on it, and then the cleaning caused me to do that.
No further question.
The final recross very briefly, Your Honor. Mr. Davis, you've been in continuous custody since you were arrested on November 4th. Is that correct?
Right.
And would you agree with me that you're in a different frame of mind today than you were on November 4th? Let me clarify that. Would you agree that today you're not under the influence of any substances?
I'm not under the influence of any substances.
That's all, Your Honor. Thank you.
Thank you. Thank you, Mr. Davis. You return your seat, sir. Charles, anything further, sir?
Defendant Trask, Your Honor. Thank you.
State any rebuttal?
No, Your Honor.
State finally rests. The evidence is opposed. Parties like to give a summation?
Yes, Your Honor.
Proceed, sir.
I think, Your Honor, that the parties kind of recognized where the real meat of this case is. It is with count one burglary. I think the evidence is pretty clear that at the time this happened, the building was locked. In fact, Mr. Sells had testified that before the defendant came in, the door was fine. After the defendant came in, the door was damaged from being forced open. The store was closed. The public wasn't supposed to be in there. So it's count two. State has proven it beyond a reasonable doubt. Count three. Davis was asked multiple times to leave. Well, after much coaxing, he left the physical store. Officers arrested him after he would not leave the property entirely. The state has proven count three. Count four, state's exhibit number one, the pipe was found in Mr. Davis's possessions. Both Mr. Colmus and Colmus and Mr. Coney both testified that based on training experience, the item is used to ingest illegal substances. In fact, the defendant.
I know 3 of the counts. Trespassing is one. Drug paraphernalia is another. And burglary is another. However, I don't know what count 1 was.
Admitted, he was testifying that he was under the influence that day. State's proving count 4.
Probably breaking and entering.
So, as I said, Your Honor, it's really count 1 that we're focusing on here. And as Mr. Kozlowski noted in his opening, it's really the.
Okay, count 1 is the burglary. So 4 is probably breaking and entering. Burglary is the one they're fighting over.
I don't think there's a real argument about whether or not the building was locked at the time. Mr. Davis entered a locked building by forcing the door. We have breaking and entering, the structure of Meijer. It's really the intent therein. I would argue, Your Honor, that Mr. Davis had already formed the intent even before he entered the building. He already started exerting unauthorized control over their property. He took the salt, took the newspapers, he entered the building. we already have an authorized control right there. Mr. Davis gives a different recollection of events. He says that he was only going in to cleanse himself. He says that he was going to give the newspapers to the Meijer personnel. But Mr. Sells testified that Mr. Davis was acting, I don't believe the word used was erratic or irrational, but I'd argue based on the evidence that would be his state of mind. Mr. Davis was under the influence of some sort of substance. He never offered to give the newspaper to Mr. Sells. He never offered to give those items. He never offered to pay for those items. As he enters the building, he has already formed that intent to exert unauthorized control over their property. And gives a different recollection of events. However, two things, Your Honor. One, he does have the prior conviction for what is legally a crime of dishonesty. I know it's one, and I'm sure the court weighs that minimally, if at all. But I would note, Your Honor, Mr. Davis has been in custody for 6 months, give or take.
And that is crazy. We see people who do way worse things get like 10 days or none. He's been in jail for 6 months already because of this.
I know this court has dealt with Mr. Davis before. Obviously, the witnesses have testified about his frame of mind that day. Mr. Davis appears in a very genial, different frame of mind today than he did then. In that time, I think Mr. Davis has had the opportunity to recollect on that evening in a manner that is more favorable to him. What he says is, well, I was only using salts to cleanse myself and I only was going to give the newspapers to them. But he's had the time to form that belief. He today is not under the influence of any substances. He is clear of mind. He's looking back in time when he knows he was already in trouble, when he was under the influence of making very poor decisions, is attempting to spin it in a light more favorable to him. What we have, Your Honor, is he's already taking the items from outside Meijer. He's entering the building with them.
Sherlock.
He's breaking and entering, intent to exert unauthorized control of the property. One thing I would note, Your Honor, is, frankly, under the law, Mr. Davis's intent on entering is to use their facilities. That is the property of Meijer. He's exerting unauthorized control over it with intent to deprive him of use or value of that property. I recognize it as a thinner argument. It is not my main argument, but under the law of the state of Indiana, that itself is theft. For those reasons, Your Honor, I would ask that you find the defendant guilty on all counts. Thank you.
Thank you. Mr. Webster. Mr. Kozlowski.
Thank you, Your Honor. Just to approach the last point that the state made, just to offer some commentary. Public defender, I'm not ashamed to say that I've reached for some arguments before, but using the water of a facility as a basis for theft, I think is the definition of a breach. I think that's so outside the bounds of what is envisioned by the burglary statute. And I think it's clear in the case law here. And my approach, Your Honor, I would present Freshwater v. State first. This is, I think, the seminal case with regard to the intent element. It's a Supreme Court case from 2006. And the court says there that the evidence need not be insurmountable necessarily, but it needs to provide, quote, a solid basis for a finding that they intended to commit that theft. In that case, they overruled the trial court's finding that there was sufficient evidence there. Now, the second case that kind of builds on this is Oster v. State. And I'm bringing this one up. The court actually found that there was sufficient evidence, but as this was a break into a store, and in that case, the court found, I think the Court of Appeals found something that I think was a bit broader of a rule that the court had envisioned in Freshwater. And they found essentially that it was enough in that case that a closed store that had merchandise and cash in it was sufficient to uphold that intent to commit theft elements. I bring that up because the facts in Oster in particular are I think, very illustrative of the issue that we're dealing with today. In that case, you have a closed store, you have a place that's clearly vacant. In our case, however, we have Mr. Davis approaching the store, and the lights are on. There are employees inside of the store. It is not terribly far away from opening time, as the representative from Meijer indicated. The employees had been coming in throughout the early morning hours to report for their shift. So in this case, I think it is very different from the Oster case, where the court can just look at the fact, well, he broke into the store, therefore he was looking to steal things. In fact, the state's own witnesses had testimony that cuts against this. Both the Meijer representative as well as Officer Coney stated that in their experience, they have never seen someone take merchandise into a facility to then take it out of the facility. It logically does not make sense. What it makes sense with is what my client has testified to. What he is saying lines up with those facts. If he were simply going to take the salt in the newspaper, he could have just taken those items. There was no need to go into the store. However, him going in and wanting to preach and having a demonstrative aid, that does line up with these facts. I don't think that the state has presented anything to indicate that he intended to commit theft once he went inside of that store. Because again, even by their own testimony, it doesn't make sense and it doesn't line up with that motive. You know, the main thing that everybody
Using their own words against them. Rude.
testified to was that the Meijer representative said he thought he had a right to be there. Clearly, he was defensive about it. He wasn't aggressive, but he was defensive. I'm sure if I were walking into a bathroom and someone told me to leave during open store, I was like, why are you telling me to leave? That's very strange. That reaction makes sense, even though he was intoxicated. Then the officer states the one thing he was really concerned about was getting cleaned, and I just want to be in here. Like, he's not talking. Did he mention the salt at all? Nope. Did he mention the newspaper salt? Nope. What evidence can we point to say that he wanted to take these things? Because again, if he wanted to take these things, he could have just taken them. If he had gone back to the back and grabbed a big screen TV, put it in his cart, okay, sure. I think that's a lot closer to what they are talking about in both in Austria and freshwater here. So, Your Honor, what my client has committed is trespass. If it were a house, it would be residential entry. I think every young prosecutor and every young public defender has had the drunk guy wandering into the house or vacant building case. That's what this is. We take in particular with specific intent, we're taking where he was at the moment. Now, we're not arguing that he was so intoxicated that he could overcome specific intent. That's not what we're arguing. I am saying on its face, the evidence shows he was not intending to steal things. Was he a nuisance? Yes. Was he trespassing? Yes. Did he commit burglary? Absolutely not. And I ask that you find him not guilty on the burglary charge, Your Honor. Thank you.
Thank you. Mr. Wexler, any final comments?
I agree. Unless you technically say the water, that's the only burglary I see. I don't see him actually stealing anything else. I see disorderly conduct. I see trespassing. I see public nuisance.
Your Honor, I would argue by the defendant's own logic, he admits to wanting to commit theft therein. What he is saying is that he is under the influence, sees the salt, it titillates him, or it activates whatever it might be. And he takes it. He takes it because he intends to exert control over it because, under his own logic, if you take it that way, he wants it for the purposes of his cleanliness or his preaching. If that's the case, then what he is effectively saying is, I found this interesting and I want it and I'm going to take it. He's already, as I said earlier, he's already forming that intent to commit, to exert unauthorized.
Then why aren't you accusing him of taking the shopping cart? He used that.
Control for Meijer's property as he is entering the building. That is the elements further. Thank you.
And Your
But
Honor,
he didn't take the salt away. The salt was still in the store. He didn't try to take the salt out of the store and away and take it with him. He was just showing the people, look, it says action. It says you have to clean.
for 1 minute, sir, rebuttal, because this is slightly different than what he had argued before. And I just want to point out, if that's the case, he already had the items.
And sir, why are you speaking right now? You do not get to go again. No. The state gets to go, you get to go, and then the state gets to go. And then that's it. Why are you speaking? You're not allowed to. Judge?
When he entered. So there's no informing the intent upon entry. I don't think that makes sense, because going in to do the crime, then that does not make sense logically. If he has already committed the crime, then he's saying he committed theft, not burglary, because the theft happened outside. So under that argument cannot fly.
Thank you. Given that the amount of time that the defendant has been in custody, and I've paid pretty close attention here, we're going to do something rather different than what normally I would do. So under these circumstances, it's clear that case law, not necessarily so much the cases putting the fine point on it that counsel's provided today, the other cases that I've read of the higher courts in Indiana, the operative moment of the intent is upon entry. It's not like you can go in and then form the intent, and then it's a burglary and all that. So keeping in mind that that's also the operative moment is the moment of entry. Circumstantial evidence, a bag of salt weighs 40 pounds. The bundle of newspapers also substantially heavy. The defendant already is carrying a poly bag in his own possessions. The court finds that circumstantially, he's not going anywhere with those items off property. Exerting unauthorized control over the property of Meijer. Anybody can bring those items that belong to Meijer into Meijer. Nobody's going to get in trouble for that. If they want to bring it to the register and pay for it, fine. If they want to bring it in and leave it laying in the store, that's rude, but it's not illegal. I don't find an intent to deprive of the use or value of their water or their facilities. You're not depriving them of the value or the use of it. You may be using it in an unauthorized way or at an unauthorized time, but that doesn't cumulatively hurt Meijer in any way. The evidence cannot support a burglary conviction under these circumstances. For the reasons stated, plus the fact that we know Mr. Davis and his trains of thought, the story that he tells, while yes, he's had time to reflect on his conduct, it is plausible and it is in keeping with his other conduct. To use that as an aid, even if he wants to take it back outside and stand out back where the salt was, where he sometimes preaches and stuff. Even at that point, if he takes the salt into the store, brings it right back where he got it, it's still not going to meet the elements. For trespass, I see trespass as somewhat analogous. I think the law that pops into my mind, it pertains to resisting. While you can resist by trying to run, and then you can resist by fighting, it's still one episode of resisting law enforcement. I think the two counts 2 and 3, are all one episode of trespassing. I do find that the state has met its burden of proof on both of those counts. However, they can't stand in double jeopardy together. So I'm only going to find him guilty on count 2. And he will be convicted of count 2 trespass of a class A misdemeanor. I do believe that the state has met its burden of proof on count 4, possession of paraphernalia. So I'll find him guilty on count 4 also, which is a class C misdemeanor, correct? Yes. With that being the case, and I'll have a written order to follow, but with that being the case, I'm curious what the party's posture is with regard to sentencing on a class A misdemeanor and a class C misdemeanor, given the amount of time that he's got in.
I would just move to sentencing today, Brown.
Mr. Webster, could you be prepared to move to sentencing today?
Give me 2 minutes to pull up jail tracker, then yes, Your Honor.
Okay. I think that would be the most fair and appropriate, legally appropriate thing to do.
I have 107.
That's supposed to be.
Okay, this is how far I got when it became 7:45 p.m. and my stream starts at 8. So the last 11 minutes, the sentence, I didn't get to see. We're going to watch it together.
If you can give it to someone, that's a lot. It's not in. Yeah, it's give me a shot.
I'm ready to record this now.
Okay. Then in that case, what we'll do, Mr. Davis, is give your attorney an opportunity to speak. Then we'll give the state an opportunity to speak and make their argument recommendation. And at the end, if you'd like to speak, then you can. Okay? Mr. Kozlowski, go for it, sir.
Thank you, Your Honor. You know, Mr. Davis, as the state and the court have noted, is a known quantity here. You know, as I've told Mr. Davis repeatedly, he's a very nice guy. He is fairly intelligent, and he has very strong beliefs in things. One thing, though, during the course of this case, and I think kind of the severity of this case really demonstrated to him, was that he needs to change his belief that using methamphetamine is a positive step towards finding enlightenment. Once the habitual offender was filed on this, unbeknownst to me, he reached out to the upper room. And he apparently has a place at the upper room when he gets out, and he intends to make use of that. You know, do you mind if I talk about what we talked about yesterday? Okay. You know, we had a pretty long back and forth yesterday about how long he's been out in the wild here, just couch surfing. He was almost 40. And, you know, he left home at 15, essentially, and was working and paying his own way through things. And, you know, he has just continually, you know, tried to make his own path in this world, is what I can say for Mr. Davis. Say what you want about him, but he is dogged in his determination to live the life that he wants. And I think that dogged determination, if turned towards something positive, could be good here. And I'm always very heartened when my clients tell me I reached out to a rehab facility on my own. That's usually something that I have to give some prodding on to get them to do. I don't know whether or not he's going to be successful. This is an addiction situation unlike any I've ever dealt with. And you know, and Mr. Davis, to be fair, is a client unlike anyone I've ever dealt with. And so I don't know. I genuinely don't. But at this point, I am hopeful that with some positive influence from people who are similarly situated to him in the spiritual world, and something that he really liked about the upper room was that there's some faith-based basis to the treatment and to the residential facility. You know, if he does go to upper room, I think he and Lawrence, the men's supervisor, I think they're going to get along fantastically, and I think Lawrence is going to be a very good influence on you. And I have told him, listen to that man. He's a smart man. He's a good man, and he will steer you in the right direction. Oh yeah, and he has recovery works as well as part of this. So again, I can't predict the future, but what I can say is he spent 171 days in jail for this. He was a nuisance, but he was not dangerous. Again, you know, what I can say about Robert is he is fervent in his beliefs, but I've never known him to be aggressive to me, at least, and I can't say that about, you know, a lot of my clients. So I think he's got hope here, and I think he can get out, and I think he can make good on this here going forward. So I would just ask that 171 days executed be his sentence, and that he go out now, hopefully with a new outlook on him. Thank you. I don't, because he just told me about it yesterday. Correct me if I'm wrong.
So Jade Servant, she says it's the crisis intervention. I even messaged her about a week and a half ago to make sure that they runs ready for me.
Yeah, I sent an email to Lawrence and the director, but I didn't hear anything back recently, but I'm not surprised. I sent it at 3 o'clock yesterday.
Ready to proceed, Mr. Wexler?
I mean, Your Honor, I could get up on my soapbox and talk about Mr. Davis's convictions and talk about this, that, and how he's a nuisance to the community and whatever. I will say, by the way, he's got 172 days credit, not 171. You know, I mean, my concern with Mr. Davis, and I'll say I charged this case, so I made the choice to, and I believed that the state had the ability to prove it beyond a reasonable doubt. Obviously, it hasn't panned out, but you know, part of my math with Mr. Davis at the end of the day is, you know, he is a nice guy. I don't think he's an active danger to anyone. I think he's a danger to himself more than the community. I don't want Mr. Davis to keep going down this bad path that he's been on and, you know, harming himself and all that. Frankly, this is the best, Mr. Kozlowski and I were talking about this a little bit before. This is the best I've ever seen Mr. Davis. He's looking trim. He's looking great. He's looking all put together. I know that he made trustee at the jail. I know he was in the kitchen. I don't know where he's at now, but
His sanitation.
he's in sanitation now.
I was too hard work for the kitchen.
Fair enough. I understand.
Hard work on.
You know, I could ask your honor that he serves another 8 days for the Class A, another 30 for the C. You know, I'm no fool. I don't think the court's going to give it to me, even if I ask. You know, I don't want to see Mr. Davis again. No offense to him, because if I see him again, it means, frankly, that he's probably going to be using again. And that's, I mean, I worry about it for Mr. Davis, and I don't want to see him in that way. You know, would another month in jail help with that? You know, maybe it'd give him another month where he's not using, but it sounds like he's setting himself up for success. And I want to see that for him. I think we all want to see that for him. So that's a long way of saying I could ask for the time. I figured time served is fine.
Thank you, sir. Mr. Davis, anything you want to say about the sentencing, sir, that hasn't already been said?
Well, yeah.
You're good? Okay, thank you. Well, you know, hopefully what you see here is, you know, the system is a thing, right? But the thing is made up of people. And Mr. Kozlowski's had multiple instances of contact with you. Mr. Webster's had multiple instances of contact with you. I've had multiple instances of contact with you.
Mm-hmm.
And none of us think you're a bad person. None of us don't like Robert Davis. Everybody likes Robert Davis, especially this best version of himself. The best version of Mr. Davis is not when he's using methamphetamine. Maybe, you know, I can see where it heightens certain perceptions and things like that, based on what I've read and heard from some of your testimony. But it ultimately it's a cheap counterfeit way to get there. You know, I mean, there's, as Mr. Kozlowski's word, enlightenment, you know, closer to God. There's a way to get there that is true and honest and real, and it's not through a glass pipe. And I hope that you are crazy successful at the upper room, and that Recovery Works is helpful to you. I hope that those things pan out for you, because nobody doesn't like you. Nobody wants to see you hurt, frozen to death. You know, none of those, we don't want any of those things to happen. We don't want there's other people out there that are not nice like you are. We don't want to see anything bad happen to you. And that's Mr. Wexler's hesitation, I think, is that he's got almost like he cares about you, and he wants to make sure that within his power and for his clean conscience that he does everything he can to make sure you're okay. And that's why he's thought about asking for even a little more time, because while you're in the jail, it's not a great place, but you're safe. And that's not great. Safe, but not free is no way to live. So we understand that freedom entails the opportunity and the ability to make bad choices. But that's part of freedom. God understands that. That's why he gave us free will. He knows we're not going to do the right thing all the time, but he doesn't want just robots that always do the right thing. He wants people that choose to do the right things, which has virtue in itself, right? So on the court's opportunity to sentence you today, I just wanted to speak with you a little bit from the heart there and tell you that I really wish you well, but we are going to cut you loose right now with a 344-day sentence. You have 172 days of class A credit, that's 344. And it's gonna be up to you, okay? I mean, right now, you know where you need to go and what you need to do.
I have a 15-year-old son, and my mom had finally sent me a picture of him.
Wow.
And I sent my mom a letter about this recovery and stuff like that. My mom doesn't send me letters yet, ever. I've been writing her letters for a long time. She sent 2 letters recently.
Yeah, that's a big change. That's a big difference.
It is a big deal.
Yeah, and I mean, one thing with people, they use and abuse drugs, they burn a lot of bridges along the way. Sometimes, I don't know your particulars, but a lot of times there's bridges that are burned and people get hurt by that. And if they didn't care, it wouldn't hurt.
Yeah.
It only hurts when you care. So if you're able to make amends with your mom and foster a relationship with your son, that would be amazing. I hope that for you.
Yeah, it will happen.
Great. Okay, well, then we're done here, except I'll have to write an order. But other than that, ladies and gentlemen, anything further? The fines and costs still become contingent.
I figured. Space Exhibit 1, I can give to Ms. Burgon.
Well, there we have it. Oh, the wind. I put the fan on. Okay. I see that everybody hated this case. Guys, we lost everybody. We're down to 17 people. This was a bad choice. I don't know why I thought this was a good case. I enjoyed watching it a lot. But it was a bad decision to put this case on tonight. It's all right. I'm going to stream again in about 6 hours, and I'll try to get something better. Because obviously this was a bad idea. But that's okay. Now we know. Do not preach over rock salt and then use water because you're going to get busted and sit in jail for 6 frickin' months. Whoo! Thank you, Martha. Guys, thanks for coming out tonight. I appreciate it. I'll see some of you in about 6 hours. I'll see the rest of you next time. I hope you have a great night. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain. 'Cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, so in